But thank you all for coming today. Let me start with a bit of an introduction of myself. I know many of you. I'm Dan Ruttenberg. I'm an attorney here at SmolenPlevy across the hall. We do many things here. We do estate planning. We do succession planning for businesses. We do general counsel work for corporations. We also do domestic relations and certain civil litigation. I normally have people introduce themselves, but I think you guys probably all know each other, so we don't need to go through that. I wanted to start with a little story. It's a true story. This happened to me not too long ago. I went to a friend of mine's graduation from law school recently. He was out in the Midwest. And while I was there was an Indian casino I happened to visit. And I was playing at a roulette table. I don't know if you've ever done that, but you get kind of social with the people that you're gambling with. And I was talking to someone next to me, and he was, I asked him what he did, and he said he was a farmer. And I'm like, wow, farmer? I've never played roulette with a farmer before. And he asked me what I did, and I said I was a tax attorney. And we kept playing a while, you know, going up, going down, and then he looks at me a little later and he goes, so you're a taxidermy, huh? And there's a couple points to that story. The first one is, hopefully after today you'll remember that I'm a tax attorney and not a taxidermy. But the other is that, you know, with estate planning, people sometimes hear one thing and expect something else when you're talking. So you want to be very clear. You want to make sure that things are clearly spelled out. And you do that with some of the tools, wills, trusts, etc. So that's my nice smooth transition into our topic today. What do you normally think of with estate planning? When someone says, hey, have you done your estate planning, what do you think? What does your client think?
Trusts, wills.
Most people, I think, you guys are a little advanced. I think most people think of a will. Traditionally, where do I want my assets to go? They're not necessarily even thinking tax planning. Maybe the more advanced clients are. But I think the average layperson, when you hear, you know, have you planned your estate, is do I have a will? And that is the #1 tool that people use. And wills are, you know, just about everyone should have one, and there are very large differences between them. They can be, you know, very simple to fairly complex. Other tools we use are our trusts. And there's a lot of different types of trusts, and we'll talk about the different types of trusts today. And they're very common, and for many people, they're the right tool to use. Another thing that I normally put with everyone is a power of attorney. And we'll go through what the powers of attorney are. I think that's something most people are familiar with. And then there's the living will, documents that sort of dictate what you want to have happen with medical issues. So those are your basic tools that we start with. So with an average client, the first thing I do is I sit down with them, and I think what everyone does is sort of takes an inventory of what they have. You know, what assets do I have, and how are they titled? Because even before you get to a will, how do assets pass? Assets can pass in a lot of different ways. You can have assets go by way of your will. You can have assets go by way of a beneficiary designation. You can have assets go by way of contract. You can have assets go by way of title. What are some examples of these? Well, if you have a house and it's titled with your wife, probably titled jointly with rights of survivorship, or actually more commonly something called tenancy by the entirety. That means upon the death of the first spouse, it automatically, by operation of law, transfers to the spouse. It doesn't go by your will. Your will could say, I want my house to go to a charity or to my child or into a trust for someone's benefit, but you titled it jointly. That's where it goes. Another example is I'm sure you're familiar with life insurance policies, and those have beneficiary designations. And again, you designate your spouse or you designate a child. It's going to go by way of that beneficiary designation. Doesn't matter what your will says. If it's owned by you, as opposed to being owned by a trust, doesn't matter what any trust you have set up say. It's going to go, and in a lot of cases, beneficiary designations, it doesn't matter what a property settlement agreement might say in the event of a divorce. Because a lot of those times, 401ks, servicemen's group life insurance, those go where the beneficiary designation says by federal law. You can't have an agreement changing that. So it's very important that people, they don't want these things going to, let's say, an ex-wife, that you make changes to those. But let's sort of start with the will. Where do we go? That's your first basic tool that people have. And the main things we do in our will is we're saying where we want our assets to go. Now, where do most people want them to go? Let's start with sort of the husband and wife, your typical family situation. And we won't go with children from prior marriages. You just have your, I won't say typical, but your 1950s family. Where did they want their assets to go?
Kids, grandchildren. To the spouse and then the kids.
Right, to each other first, and then to the children. That's often referred to as the I love you will. I love you, I leave you everything, and vice versa. That is pretty much where most people do want their assets to go, not taking into account are the children old enough or tax considerations or those sorts of things. They want them, at least the benefit of those dollars, to go to each other and then to the children. Now that's not that complicated to do, although there are a lot of problems with doing that. There's some traps for the unwary. But then we leave assets to the children. And that's, leaving assets to each other is one thing. And most of the time we're leaving it to them outright. But now let's bring the children into the equation. There's all sorts of issues that come up when you have children. The first issue is, and you deal with this in your will, guardians. You need to designate guardians. The last thing you want for your children is a custody battle once the parents have died. I mean, you want to have that clear. You want to say, whose gets it? I don't care what you heard me say. Taxidermy, I designated so-and-so to be the guardian of that child. But then there's also issues with, and that's, guardian handles the person, doesn't handle the money, handles, who's in charge of making decisions, where you go to school, medical decisions. The person in charge of the money, if your child's 50 years old, most likely is going to be your child. But if your child's 6, well, now we need to have someone put in charge. When do you want, first of all, when do you want your child to inherit money? Do you want your child to inherit money at age 18, when they are legally adults and they're deciding whether or not they want to go to college? I told this story yesterday. I'll tell it here again. And this is another true story. I was spending, I think I was 19. I'm living in Ocean City, Maryland. And one of the people down there had been in a car accident previously and had just gotten $50,000 in a settlement. And I was like, wow. I remember thinking this. If I had $50,000, I could live in Ocean City for the rest of my life. I would never have to go to college. I mean, that was going to be my plan. Thank God my parents, didn't leave me any money. But I think I was fairly typical at the time. I'm sure everyone was thinking that. So the point is, you don't want, inheriting that kind of money at that age is very dangerous to a child. You need to have a very mature child make right decisions. So you don't want to leave it to that child at age 18. You want to put it in a trust until they reach a more appropriate age. What is that age? That really will depend on the child and often, the parents' morals on that. But pretty much everyone agrees 18 is too young. A very common starting point, we do a third at 25, a third at 30, and a third at 35. But I often change that. I might do a 35, 45, 55, or could make it earlier. Or if the child has special needs, that can come into play, and you could do a trust for a life if you need to. And everything we're talking about now, you can accomplish in a revocable trust or a living will.